ladies and gentlemen, I think we've got almost everyone cleared through the front door security system, and I'm told it's time to start. So welcome everybody to this, the annual Law Oration, proudly presented by the Victoria Law Foundation. They have been held since 2005 in this magnificent courtroom, with a very historic room. And they are designed to reflect upon important matters, legal matters that affect us in our lives and shape our community. This evening we are privileged to have as our orator the President of the Court of Appeal, the Honourable Justice Maxwell. I'm Hartley Hanson. I chair the Victoria Law Foundation as the nominee of the Chief Justice, and I would immediately acknowledge the traditional custodians of the land on which we meet and recognise their abiding connection to the land, its waterways and community, and pay my respects to the elders past, present and emerging. Before I invite the Chief Justice to the Honourable Anne Ferguson to open proceedings, I have three quick housekeeping points. First, please make sure you've turned off your phones. Secondly, the event is being recorded as a live stream and for our website, so if you have any questions regarding that, please speak to one of our staff at an appropriate time. And thirdly, there will be time for questions following the oration. And I ask you in advance to, if you're going to ask a question, think about what it might be, and when you do ask it, do so in a clear and loud voice. Now, without any further ado, I would welcome the Chief Justice to open the proceedings and introduce our orator. Thank you, Chief Justice.
Thank you, Hartley. Good evening, everyone. It's a great joy to see the courtroom full and the upstairs gallery pretty full as well. So a very warm welcome to what's a cold room, but a very warm welcome on behalf of the Victoria Law Foundation and also on behalf of the Supreme Court of Victoria. It is a pleasure for me to be here tonight to welcome you in the Banco Court. As Hartley has mentioned, it's a very prestigious court. It's a ceremonial court in this building. It was designed to create an atmosphere appropriate to the solemnity and importance of the events that occur within its walls. The Banco Court is used not just for orations such as this, but also for the admissions of new lawyers, a very special day for each new lawyer when they're admitted to practice, and it's also used for ceremonies such as welcome to new judges, where the profession welcomes the new judge to the bench. It's also being used increasingly as a setting for welcoming community members to the Supreme Court to learn more about its work and the people within it. So what better place for tonight's event to take place? Because the oration is one of the highlights of the legal year. As Hartley has mentioned, it serves as a public forum to explore important legal issues affecting our lives and shaping our community. Past orations have covered topics as diverse as whether judicial independence matters, ending mass atrocity crimes and sentencing. So I commend the Foundation for its valuable contribution to Victoria's justice system and democracy, and I also acknowledge those within the Foundation who've made tonight possible. In particular, I'd like to acknowledge Lynn Holtain and her team at the Foundation, and also the Foundation Chair Hartley Hanson, who we heard from briefly. Tonight's topic is equity and good conscience, the judge as moral arbiter and regulation of modern commerce. The oration will explore unconscionable conduct as an equitable and statutory concept, highlighting the role judges play in making moral judgments about commercial dealings. It will be presented by one of my colleagues, Justice Chris Maxwell, President of the Court of Appeal, as we've heard. Chris began his practice at the Victorian Bar in 1984. He was appointed to Queen's Counsel in 1998 before being appointed as President of the Court of Appeal in 2005. In 2015, Chris was made a Companion of the Order of Australia in the Queen's Birthday Honours. It is my particular pleasure to introduce him this evening. We've been colleagues now for a number of years, many years in fact, and of course we have sat together on the Court of Appeal. One of the things that I've always admired has been his intellectual rigour in sitting with him as a fellow appellate judge, but I've always admired his enthusiasm for the law, and I very much value, as the Chief Justice, his support and collegiality to both me and the other judges within the court. Quite aptly, Chris and I have had the pleasure of sitting together in this court on occasion. He was once described as having an innate sense of social justice, fairness and a strong moral code, as well as a wealth of experience and knowledge of the law. Needless to say, I've got no hesitation in endorsing those remarks. So I'm looking forward to hearing from him tonight. Please join me in welcoming Chris Maxwell.
Thank you very much, Chief Justice, for that generous welcome, and friends and colleagues for making the effort to be here on a cold August night. It's a special privilege to have been asked to deliver this oration. The Victoria Law Foundation is committed to promoting public understanding of the law. I can't think of a more important objective for a public authority associated with the justice system. Day by day, judges of this court struggle to inform, communicate, explain what we do, and everything the Foundation does to lay the groundwork for better understanding of what's going on is a step in the right direction. Needless to say, I've learnt a lot in preparing the oration. As I think you'll gather from the questions I'm going to pose, I see this as an exercise in learning together. There is, of course, something about an oration, not least that it's expected to be quite long. When I asked the organisers earlier in the year how long I should speak for, I was told, oh, well, 50 minutes would be fine. I just thought I would alert those of you who had other plans that I don't think I'll be going quite that long, but certainly the speech has got longer each time I've done more work on it. And so I'm going to spring a surprise on you by doing what I've done in one or two places over recent years, and that's have a break halfway, not for you to go and get a coffee, but just for you to stand up and have a stretch. That will give me some chance that you'll be awake for the second half. Let your conscience be your guide. If you're familiar with that phrase, you probably assume, as I did, that it comes from the Bible or from a moral philosopher like Aristotle or Aquinas. In fact, it was said by Jiminy Cricket to Pinocchio in the 1940 Disney film of the same name. I only found that out this morning when I'd looked in vain in the Oxford Dictionary of Quotations to find it. Disney doesn't qualify for that dictionary. For students of popular culture, I should mention that there will be one more popular culture reference later in the speech. Nearly 80 years after Pinocchio, we don't often hear references to conscience as a guide, though most of us have a working sense of what it means for a person to have a guilty conscience or have something on their conscience. I suppose whether conscience is a reference point for you will depend, as a colleague mentioned to me a couple of hours ago, on whether you had a religious education, and if so, what kind. But given that it isn't something we speak of much, it seems surprising, I want to suggest, to find that a rule expressly founded on conscience is at the heart of Australian consumer protection law. I'm referring, of course, as the Chief Justice foreshadowed, to the prohibition against unconscionable conduct. That means, as the High Court recently confirmed, conduct which is against conscience. My purpose in this oration is to investigate how that concept is understood in law, and more particularly what its implications are for judges and lawyers and those engaged in business. Unconscionable conduct has a very long pedigree in the law. For centuries, courts of equity have intervened to set aside contracts and other dealings because of unconscionable conduct, that is, conduct on the part of a party who stands to receive a benefit from a transaction which in the eye of equity cannot be enforced because to do so would be inconsistent with equity and good conscience. That, of course, is the phrase in my title. So conduct was deemed unconscionable if it was contrary to the dictates of good conscience, and the Court of Equity viewed itself as the court of conscience. As Justice Keane noted in his 2009 lecture on the conscience of equity, as early as the 15th century, the chancellors in the Court of Chancery were prepared to satisfy the demands of conscience even though their action involved a dispensation with the rigid rules of law. And so it is today. It was, of course, equity's conception of unconscionability which gave Mr and Mrs Amadio their famous victory in the High Court against the Commercial Bank of Australia in 1983. What was said by Justices Mason and Dean in that case is still regarded as the definitive statement of the criteria for equitable intervention on that ground. But crucially for present purposes, that same equitable conception, that is to say the centuries-old notion of unconscionability, has been given a very modern expression in the national laws of the Australian Parliament, which regulate business dealings with consumers and dealings between businesses. Both the ASIC Act, that's the Australian Securities and Investments Commission Act, and the Australian Consumer Law contain express prohibitions against engaging in conduct which, quote, is unconscionable within the meaning of the unwritten law, unquote. That's what it says in the statute. That reference to the unwritten law has been interpreted to be a reference to equitable doctrines. So the statute says if it would be unconscionable in equity, it's unconscionable under this provision. But just to make the position more confusing, there is in each statute a companion provision which prohibits conduct, quote, that is in all the circumstances unconscionable, unquote. In a deliberate effort to give those latter provisions a broader reach, Parliament has expressly declared that those prohibitions are not limited by the unwritten law. In other words, Parliament wanted the courts to go further. My concern this evening is not, you'll be relieved to hear, to lead you through the case law on unconscionable conduct, fascinating though it is. Instead, I want to highlight the implications of our continued use in the second decade of the 21st century of this powerful but elusive concept of good conscience. That we set so much store by a quintessentially moral concept like unconscionability raises, I want to suggest, some unexplored questions about the role of the judge as moral arbiter and moral reasoner, and about the tension between the moral aspirations of the law and the profit-driven dynamics of the market economy. We should start by acknowledging that unconscionable is a word hardly ever encountered in ordinary usage. See if you can remember an occasion on which you described or heard someone else describe a person's conduct as unconscionable. There are lots of adjectives available to us, but I don't think that's one many of us would reach for very often. It's surely remarkable that the Commonwealth Parliament has for the past 3 decades relied on a term likely to be both unfamiliar and unintelligible to those whose conduct it is intended to regulate. Why, it might be asked, do we persist with opaque notions at the heart of business regulation law? And as Justice Edelman pointed out in his judgment in Cobalt recently, the term unconscionable conduct was retained despite a 1997 recommendation of a federal parliamentary committee to replace it with the term unfair conduct. I'll suggest at the end of this talk that it might be time for us to take up that recommendation. As I've said, unconscionability is an explicitly moral concept, and the embedding of that concept at the centre of the law on business regulation and consumer protection means that judges have to make moral judgments when there's a contested issue. This seems to me to raise interesting questions about how those judgments are made, as follows. Is it appropriate for a judge to be the moral arbiter of business dealings? That's an issue of legitimacy. Does the judge have the requisite skill to be a moral reasoner? That's an issue of capability. How can such an imprecise standard as against good conscience be reconciled with our commitment to the rule of law, which values certainty and predictability in the law so that citizens can arrange their affairs knowing in advance what is and what is not prohibited? That's an issue of legal certainty. And there are important related questions about whether these laws can make a positive difference in advance in the way business is conducted. That is, before things are done rather than afterwards. Those questions, I suggest, are, first, is it realistic to expect the moral aspirations of equity, of the law of good conscience, to be fulfilled, that is, to have a positive influence on behaviour in the marketplace by creating moral self-awareness? And secondly, if we as a community remain committed, as we are, to the maintenance of these moral standards, what more can the legal system do to advance them? Before I address these questions, I want to emphasise that both my initial interest in this subject and my more recent thinking about these questions have been stimulated and enriched by the work of 4 academic writers. I'll name them. Professor Paul Finn, later a Justice of the Federal Court, whose 1989 article, Commerce, the Common Law and Morality, first set me thinking. Professor Matthew Harding of Melbourne Law School, who's written extensively on the law of equity and particularly on this issue of equity and the rule of law. Dr. Irit Samet, reader in private law at King's College London, whose recent book, entitled Equity, Conscience Goes to Market, marvellous title, helped me to understand equity's moral aspirations. And Dr. Sinead Agnew, a lecturer in property law at University College London, whom I met earlier this year and whose 2018 article, quote, The Meaning and Significance of Conscience in Private Law, illuminated the multiple ways in which the concept of conscience is brought to bear in private law doctrines. I mention these academics not to cloak what I'm about to say with any particular intellectual respectability, but rather to underline a point which I find myself repeating quite often these days, namely that the work of practising lawyers and judges is immensely enhanced by the work of legal academics. The work of the Victorian Court of Appeal, you may or may not know, is dominated by criminal appeals. As much as 50% of our work concerns appeals against sentence. Very important and entirely fascinating work. But it has the result that questions of private law doctrine arise at best intermittently. For example, we had a recent treat We had a special treat recently when there was an appeal about the tort of conversion. We could hardly contain our excitement. And in the same way, there's been the merest sprinkling of unconscionability appeals in my 14 years at the Court of Appeal. It won't surprise you to know that, at least for me, when I'm called on to adjudicate a particular case involving some aspect of doctrine, it's of the greatest benefit to have the assistance of academic writing. Their systematic analysis of a body of law, of the kind that no judge or practitioner can do, elucidates the governing principles, identifies trends in the development of the law, and provides the essential context within which to approach the case at hand. So it was with the conversion case. We need to ensure that as judges that we are open to receiving that assistance where appropriate, and that as practitioners we are alert to draw relevant academic materials to the court's attention. Let me turn now to what I've called the aspirations of equity. Dr. Samet, in the book Conscience Goes to Market, argues that the function of equity is to ensure, so far as possible, that legal liability and moral duty should coincide. In her view, quote, the terminology of conscience also has an important communicative function in that it alerts people to the fact that equity takes serious consideration of the interpersonal morality aspect of their relationship with other players in the market. And I pause on that because that, it seems to me, is a radical notion, and yet it expresses, I think, very eloquently what we can understand to be the aspiration of these notions. That is to say, there should be serious consideration of the interpersonal morality aspect of relationships in the market. More strongly still, Samet argues that, quote, the use of a familiar term like conscience effectively communicates to the citizenry that they're expected to make full use of their capability as moral reasoners when they head off to market. And finally, she says, when equity uses a term like conscience, it builds on the expressive power of law to send a strong message. Quote, the law expects you to rise above narrow considerations of self-interest when dealing with other market participants. Sinead Agnew likewise argues that the language of conscience has a valuable role to play in encouraging moral agency. It suggests, she argues, that if the defendant has knowledge of the relevant facts, this activates her capacity for moral reasoning. It's only through the process of moral reasoning, through the operation of her conscience, that she can work out what she ought morally to do in the circumstances. Matthew Harding refers to this as the expressive function of the law, and all of you who participate in the operations of the law will have reflected on that important notion. It's not just the advice to the client or the decision in court or the enactment of the law in Parliament. It's the expression through the practice and the decisions and the statutes of the values which are embodied in the law. Is it realistic to think that those values are communicated? Harding says, equitable doctrine may guide conduct by creating conditions in which citizens are encouraged and expected to engage in moral deliberation and take responsibility for their own actions in accordance with law. An issue I'll return to is whether this is a realistic aspiration for the law. The shocking reports we've all read about large-scale and widespread unethical behaviour in the financial services industry would tend to suggest that not very much moral reasoning has been going on there. The dictates of good conscience do not appear to have held much sway when decisions have been made by service providers about what sorts of transactions to embark on, which sorts of customers to engage with, or what marketing and selling techniques are to be adopted. A question for this audience is that a failing in the law? either as enacted or as applied? Even if it's not, could the law, that is, judges and practitioners, do more? That's obviously an important question. Are lawyers sufficiently emphasising to their commercial clients the moral content of these laws with which they are obliged to comply? Are the courts applying these provisions as the legislature intends and the community expects? As the Royal Commission demonstrated, the question of whether and when regulators take legal action against market players is critical to the maintenance of proper standards of commercial conduct. Inevitably for them, the question is, how will the judge respond to this claim of unconscionable conduct? I was interested to note that ASIC, the Companies and Securities Regulator, has just commenced proceedings against ANZ in the Federal Court, alleging that the charging of certain fees, which ASIC says the bank knew were unlawful, or at least there was a risk they were unlawful, was unconscionable conduct. Let me pause to say a little bit more about the legal framework. In Amadio, as many of you will recall, the High Court held that the bank could not enforce a mortgage which Mr and Mrs Amadio had given in order to support an overdraft increase for their son's failing business. The mortgage was held to be unenforceable because the bank's conduct in the transaction was unconscionable. And that was because the parents were in a situation of special disadvantage, which seriously affected their ability to make a judgment as to their own interests, and the bank knew, or ought to have known, of that special disadvantage and took unfair advantage of it. It should be mentioned that the court was split 3-2 on that question. The minority would not have found unconscionable conduct. I'll return to that issue of uncertainty and divergence in judicial opinion later. In the more recent case of Kakavas, the full High Court clarified the nature of the equitable test set out in Amadio. And I'm just going to highlight some terms here to draw to attention the nature of the judgment being called for. Essential to the principle stated in Amadio, the court said, is that there should be an unconscientious taking advantage by one party of some disabling condition or circumstance that seriously affects the ability of the other party to make a rational judgment as to his or her own best interests. The abiding rationale of the principle is to ensure that it is fair, just and reasonable for the stronger party to retain the benefit of the impugned transaction. The latest word on statutory unconscionability, that is the in all the circumstances unconscionable provision, is from a decision in June this year by the High Court in ASIC and Cobelt. In that case, proceedings were brought by ASIC alleging that Mr Cobelt had engaged in unconscionable conduct in the provision of credit to Indigenous Australians living in remote communities. By the narrowest of margins, 4-3, the High Court held that his conduct was not, in all the circumstances, unconscionable. Strong views expressed both ways. The Chief Justice and Justice Bell accepted that the statutory standard prohibited, quote, conduct that answers the description of being against conscience, unquote. I pause on that just to reinforce the point that in 2019 that is still the test. And the question is, what would that mean to you if you were the adjudicator? Now, of course, there's a lot of law in this area. The judge is not without assistance in deciding that question, but it only needs to be stated for its value-laden character to be obvious, to say nothing of its vagueness. Conduct that answers the description of being against conscience. Of course, time doesn't permit me to refer you to the literature which explores whose conscience. And there is this interesting notion of it not being the personal conscience of the judge, but something called the juridical conscience. That's a topic for another oration. Their Honours concluded that Mr Cobelt hadn't taken, quote, unconscientious advantage of the vulnerability of his customers. Justice Keane came to the same conclusion. And I'll read this because, again, it throws up what I think is so interesting about this and difficult about this field of discourse. Justice Keane said, the use of the word unconscionable in the section, rather than unjust, unfair or unreasonable, which are familiar in consumer protection legislation, reflects a deliberate legislative choice to proscribe a particular type of conduct. In its ordinary meaning, the term unconscionable requires an element of exploitation. The term imports the, quote, high level of moral obloquy associated with the victimisation of the vulnerable. For those of you who haven't heard that particularly archaic word, it's spelled O-B-L-O-Q-U-Y, obloquy. Interestingly, in his judgment, Justice Gageler apologised for having used the term moral obloquy in an earlier judgment. He said it had been the subject of both academic and judicial criticism, and he regretted having used it. His view now, with which I respectfully agree, is that the phrase is arcane terminology, the deployment of which assists not at all in working out what conduct is prohibited. Instead, Justice Gageler said, the conduct prohibited by the section is conduct that is so far outside societal norms of acceptable commercial behaviour as to warrant condemnation as conduct that is offensive to conscience. So that's the definitional paradigm for Justice Gageler. So far outside societal norms of acceptable commercial behaviour as to be offensive to conscience. And the judgment of what's offensive to conscience, His Honour went on to say, is informed by a sense of what is right and proper according to values which can be recognised by the court to prevail within contemporary Australian society. Now, assuming that's the right frame of reference, it's immediately obvious that there is an empirical exercise required. What are values which prevail within contemporary Australian society, and what would be recognised as right and proper? Having said something about the moral underpinnings of the notion of unconscionability, let me turn to the questions about the function of the judge. As we've seen in the debate about the judicial role in adjudicating questions of human rights, and you'll be aware of the line of argument which says they're not elected and they've got no legitimacy and no authority to decide such questions, there's a question we need to address about the legitimacy of a judge sitting in moral judgment on the conduct of others. That question may be thought to be accentuated when what is in issue is not interpersonal morality in the private sense, which might be thought to fall at least within the judge's own experience, but dealings in the marketplace with which most judges have limited familiarity. Now, that's the midpoint. Can I invite you to stretch or pause for 2 minutes, and then I'll resume for the home stretch. Colleagues, we might get underway if that suits you. The danger with having a break halfway through is that lots of people might leave, but my impression is that not too many have taken that opportunity. So this is the question of legitimacy. My contention is that, in fact, judges are constantly called on to perform the role of moral arbiter. I would argue, moreover, that the community depends, whether consciously or unconsciously, on judges doing precisely that. An obvious example is the judgment made every day by sentencing judges and by the Court of Appeal when a sentence is challenged on the moral culpability of an offender. We regularly debate with counsel the extent of moral blameworthiness which should properly be attached to the offending conduct, and that judgment has a direct bearing on the size of the fine, or more often the length of the prison term. In the same way, all sorts of legal rules depend for their application on the judge's assessment of what was reasonable in the circumstances, or of how the reasonable person might have behaved when confronted by a certain state of affairs. Judgments of that kind are often infused with moral considerations. We need only think of the judgments made in the field of negligence about the existence of a duty of care and about whether, in the case at hand, it was breached. What could reasonably have been expected of a person in that situation? And of course, the neighbour principle, which we all remember so well from first year torts, is a principle of moral relationship. What is it that I owe my neighbour? The late lamented legal philosopher John Gardner wrote a marvellous article entitled "The Many Faces of the Reasonable Person." In that article he spoke of what he called the zone that the reasonable person occupies, which he said was legally deregulated. One could call it a zone of legally licensed adjudicative discretion, which I think is entirely apt, within which the judge makes her best judgment in applying what are non-legal standards. Public confidence in the court system would, I think, be enhanced if this moral dimension of judicial work were better understood. There is, as we're all aware, an abiding perception of the legal system as constrained by an overly rigid set of rules and administered by judicial officers who are hopelessly out of touch. Those perceptions are likely to be more readily dispelled, I would argue, if more were known about what the job actually requires. The example I always give is of Justice Paul Coughlin's sentencing of Arthur Freeman, who, as many of you will recall, murdered his daughter by throwing her from the Westgate Bridge. It was a crime which had deeply shocked the Victorian community. Justice Coughlin's sentence, which was broadcast publicly on morning radio, exemplified moral reasoning. It was delivered calmly, dispassionately and seriously. The public broadcast served, it seemed to me, to reassure the community by demonstrating that the responsibility for that kind of moral reasoning and moral judgment was in safe hands. What then of capability? Why would we think that judges have the necessary equipment, either intellectual or philosophical, to enable them to be moral reasoners? For that is certainly what is required, as we've heard. The judge has to decide whether it was conduct which, in all the circumstances, was against conscience. There is, I think, a respectable view that judges have, or at least can develop, the requisite capability. Lord Gough, in a 1989 speech in Australia, described the judge's functioning in the individual case as reasoning upwards from the facts and searching for principles which accord with a professionally developed sense of justice and an intuitive sense of a just result in the case. The Australian legal philosopher John Tasiulis argues that, quote, in modern democratic societies, considerations such as the relative political insularity of judges, that is, political independence, and the piecemeal and discursive nature of their decisions mark them out as well suited to perform certain vital social tasks through ethical reasoning. And Dr. Samet argues that various attributes of the judiciary have a positive impact on the chances that its members get the answers to moral questions right. First, the procedure and etiquette of adjudication create a working environment in which risk factors such as bias are constantly controlled for. Second, on the bench, judges become habituated to listening to both sides before making up their mind, gain proficiency at sifting truth from falsehood, and get accustomed to exercising a detached judgment. These virtues and skills are necessary in a good judge, but they also make it easier for them to excel as moral reasoners. What do you think? I turn to the next question concerning the uncertainty said to follow from the use of such an imprecise concept as unconscionability. I've already mentioned the split decision in Amadio. A later decision in Bridgewater was also 3-2 and Cobalt was 4-3. And the formulations I quoted to you demonstrate just how much room there is for minds to differ on whether particular conduct is unconscionable. In the field of statutory interpretation, I have, both in recent decisions and in an article just published, emphasised the rule of law virtues of clarity, certainty and predictability. Those purposes, I argue, are best served by giving primacy to the statutory text. Of course, that is exactly what the High Court has prescribed in its decisions over the last decade. Why then should we accept an undefined, perhaps indefinable concept like unconscionability? Doesn't a law which uses that language conflict with the value of certainty in commercial life? Wasn't Professor Burks right when he said, quote, "Unconscionable is so unspecific that it simply conceals a private and intuitive evaluation. The law must be stated so as to facilitate prediction and advice." In this area, I'm persuaded that other values must prevail over the demand for certainty. Reading what the academic writers have written has entirely persuaded me that it is a positive virtue of the equitable and statutory concept of conscience that it is not rule-like, that it does establish open-ended standards and it does prevent unfair advantage being taken of the rigidity of rules. Matthew Harding puts the point very well. Indeterminacy in equity may promote moral purposes of other sorts. For example, by formulating doctrine according to the vague concept of conscience, equity may demand of citizens that they sometimes work out for themselves what conscience demands as they act and plan. On this view, the uncertainty associated with this concept positively advances the high aspirations of equity, that by promoting and encouraging moral awareness and moral agency in the marketplace. In other words, the risk that your conduct might be found to be unconscionable and the uncertainty about where the limits might be drawn if the matter went to court should encourage not only moral self-awareness but a precautionary approach to business dealings. So a bank officer or an insurance salesperson might adopt a rule of thumb along the following lines, quote, "If I have a concern that this might be unethical or unfair, or that I might be taking advantage of a vulnerable person, I probably shouldn't do it." It is in this sense, I think, that Justice Keane in Cobalt spoke of unconscionability as, quote, "a statutory norm of conduct." The problem, as I suggested earlier, is that those to whom this norm is supposed to apply would almost all be unaware of its existence, and even if they knew about it, wouldn't know what it meant. I want to come to a point which I owe to Professor Brian Horrigan, who's in the audience tonight, who's important article on this topic from some years ago I read in preparation, and it's this. For many years before the Royal Commission was announced, the Banking Code of Practice contained an explicit promise of ethical conduct. Quote, "We will act fairly and reasonably towards you in a consistent and ethical manner. In doing so, we will consider your conduct, our conduct, and the contract between us." In short, the aspiration of the Australian Bankers Association was that there should be this sense of proactive engagement with ethical obligation. On the issue of certainty, you'll be interested to know a little piece of Victorian legal history. In September 1992, I discovered the Victorian Law Reform Commission published a discussion paper entitled An Australian Contract Code. The proposed code, drafted by Fred Ellinghouse, who many of you will know from law school days, comprised 27 articles. Its touchstone was the requirements of conscience. I'll only read one of the articles, which expressed what was said to be the overriding principle. Quote, "A person may not assert a right or deny an obligation to the extent that it would be unconscionable to do so." My researchers don't reveal why that proposal wasn't taken up as the basis of a new contract code. I turn to deal with what appears on the basis of what we've all been reading to be the commercial reality. It would not be an overstatement to say that equity's moral aspirations appear to remain largely unfulfilled. The pursuit of self-interest has seemingly become so intense as to obscure regard for others and respect for the vulnerable. This is not a new concern. As long ago as 1998, Lord Millett, an English judge, wrote in the Law Quarterly Review, "There's never been a greater need to impose on those who engage in commerce the high standards of conduct which equity demands. The common law insists on honesty, diligence, and the due performance of contractual obligations, but equity insists on nobler and subtler qualities: loyalty, fidelity, integrity, respect for confidentiality, and the disinterested discharge of obligations of trust and confidence." We've all been exposed to reports from the Royal Commission into banking about predatory behaviour, about the pressuring of customers to take loans or buy insurance in circumstances where they were almost certainly not able to make a proper judgment as to their best interests. Commissioner Hayne put it bluntly in his interim report as follows, quote, "Too often the answer seems to be greed, the pursuit of short-term profit at the expense of basic standards of honesty." More recently, in July, we saw the report by ASIC on consumer credit insurance. That's insurance which provides cover for consumers who have borrowings against the risk that they won't be able to meet their loan repayments due to unemployment, sickness or injury. Insurance of that kind, the report tells us, is usually sold by lenders to consumers with a credit card, personal loan or home loan. Time doesn't permit me to read the list of the various harmful sales practices set out in the report, but the report indicates that ASIC is requiring lenders, that includes the four major banks, to undertake, quote, large-scale remediations with over $100 million expected to be paid to 300,000 plus customers. That's very large-scale misconduct, according to that report. And I note that this was the very topic on which, according to the evidence at the Royal Commission, the then CEO of the Commonwealth Bank told his now successor that he should, quote, temper his sense of justice, unquote. There is an obvious tension between the drive for profit and competitive advantage, which is at the heart of the market economy, and conscience-based regulation, which calls for ethical self-awareness, restraint, and sensitivity to a customer's potential vulnerability or disadvantage. In his 2009 lecture, Justice Keane said, quote, "Equity never set out to bring to heel what John Maynard Keynes described as the uncontrollable and disobedient psychology of the business world. Accepting all of those drivers, it must, I think, also be acknowledged that in making decisions about whether to acquire financial products or services, most consumers are inescapably at a disadvantage. First, for most consumers, decisions of that kind only arise relatively infrequently. Unlike the traders they're dealing with, consumers are not in the business of lending or investing or taking out insurance policies. That's the disadvantage of unfamiliarity. Then there's the disadvantage of complexity, as anyone who's read a product disclosure statement or the terms and conditions of an insurance policy would understand. These are, obviously enough, products and services which are not readily comprehensible to the lay consumer, whether having the benefit of a tertiary education or not. Buying a car can be hazardous enough, but for most of us, we have a fair idea of the nature of the product we're buying. Weighing up the risks and rewards of a financial product is an altogether different exercise. So the question which these considerations throw up is this: is the aspiration of conscience-based law reconcilable as a form of market regulation with a market whose drivers all push in the opposite direction? And that brings me finally to what's been said more recently about the way forward. In his final report, Commissioner Hayne made some very important statements about the culture of a financial services entity. Relevantly, I want to read the following. There is no single best practice for creating or maintaining a desirable culture, but one necessary aspect of a desirable culture is adherence to the basic norms of behaviour described elsewhere in this report, and he lists them. Obey the law, do not mislead or deceive, act fairly, provide services that are fit for purpose, deliver services with reasonable care and skill. When acting for another, act in the best interests of that other. I should mention also what was said last week by Mr Wayne Burrows, the chairman of the banking regulator, APRA, Australian Prudential and Regulatory Authority. I find when I go for coffee in the morning and I glance at the Financial Review, there's almost always something on this topic. This particular Financial Review carried the headline, quote, "APRA wants bankers to behave more like lawyers," unquote. That caught my eye, and I thought I should track down the speech to see just exactly what aspects of our proud profession he thought should be translated. What Mr Byers actually said on that topic was a single sentence, quote, "A stronger foundation of professionalism, more akin to that for lawyers, accountants and actuaries, would no doubt help." Slightly overstated headline, one might think. But back on my topic, he said this: as individuals, we are faced with a myriad of decisions every day in which we are able to exercise our discretion. He's talking to market participants. The fact that misconduct or unethical behaviour may be possible or even inadvertently incentivised is not a licence to take advantage of it, nor even to turn a blind eye to it. There's nothing to fear and much to gain, he said, from having a workforce that serves all interests in good faith, competes hard but with honour, exercises ethical restraint in their choices, speaks out against wrongdoing, and takes accountability for their own actions. In that speech, Mr Byers expressed support for something called the BFO. Now, some of you will have heard, and this is the second pop culture reference, of the BFG. A glimmer of recognition. Roald Dahl's irresistible character, the big friendly giant. This acronym is rather different. It stands, I've discovered recently, for the Banking and Finance Oath, with a capital O. The oath has been formulated and is being promoted by an independent organisation whose stated purpose is, quote, to improve our society by raising the moral and ethical standards of the banking and finance industry through the implementation of the BFO. And there are a number of signatories, and it has both a board and a policy board with very senior members of the business community. Now, I won't read the whole oath, but it relevantly says, trust is the foundation of my profession. I will pursue my ends with ethical restraint. I will speak out against wrongdoing and support others who do the same. Another visit to the coffee shop revealed a report about business schools rethinking their ethical training for those who are doing courses like MBA. It was reported, and I've since been in touch with Dr. Rosemary Sainty of the UTS Business School in Sydney, who convened a deliberative forum to consider the role of business schools in response to the Royal Commission report. And she publicly reported later that the themes which emerged included, quote, the responsibility of business schools to cultivate critical reasoning and individual moral accountability in our students, and to challenge taken for granted amoral assumptions in traditional business school curriculum and practices. Now that again sounded quite radical to me. The question for this audience, I think, is whether we as judges and practitioners need to do more or do better. Should we be rethinking how we teach commercial law, or how we practice it, or how we adjudicate it? In his dissenting judgment in Cobell, Justice Edelman set out the legislative history of these unconscionability provisions, and he says that Parliament has repeatedly amended the statutory proscription against unconscionable conduct in continued efforts to require courts to take a less restrictive approach. Now, if that's right, why are courts taking a restrictive approach? Are we not understanding, recognising, enforcing the moral aspirations of this law? Are we not recognising that Parliament wants this to apply with real force? It may be that the training of lawyers in or aiming for commercial law practice should give much greater emphasis to these notions of good conscience. By that I don't mean that we would expect lawyers to stand in moral judgment of their clients, but it must be their professional responsibility to make sure that their clients have a good appreciation of the moral dimensions of these legal prohibitions which prohibit conduct which is against conscience. Seems to me, as I've thought about it, you couldn't explain to your client what the parameters are for the conduct of the business without saying that one of the limits is conduct which is against conscience, which ought to prompt the kind of reflection which I've referred to and which equity aspires to encourage. Moral deliberation. The client should ask the law, what does that mean? In practice, what limits does that impose on what we do in our dealings with our customers? And as I've said, there seems to me to be a live question as to whether the courts are being too restrictive. Or, as I suggested at the outset, is the problem with the standard? That it uses arcane language not likely to be understood. I want to leave you with the suggestion that we should consider how these regulatory schemes would work if we had a prohibition on conduct which was, quote, in all the circumstances unfair. It mightn't make the application of the law more certain, though I don't think it would make it any less certain, but because at least everyone has a working sense of what's fair and unfair, albeit that views will differ, that change might promote better understanding by all concerned, and it might be hoped higher standards of conduct in the marketplace. Thank you.
Well, what a wonderful, provocative, and I think in one sense rather lifting the veil a little bit on what happens when judges go to work in these cases. And the more that that's plain, the better it is. And yes, that old phrase about moral obloquy, we were talking before in that short break, Chris, sometimes these phrases are handed down and you should stop and think, what are we actually saying? And how can we put it so that the reader can understand? But Chris, that was wonderful. Thank you very much. The labour that went into that was extensive. Now that we do have time for questions, I'm going to wind it up at 7:25, whether you have more or not. So, as I said before, if you do have a question, keep it short, keep it clear, so it gets picked up by the things that are looking at you and picking out the sound, etc. I'm just going to stand a little to the side here and ask Chris to come here, up here. We do have a microphone somewhere, don't we? Now there's a question just over here, which will make it a bit easier. And if you could state your name and organisation, if there is.
You didn't mention the new test that we read about all the time now, the pup test. Should that be introduced into the legislation?
Well, I think that's a terrific question, because if it's about what would be regarded as right and proper, according to the values of the Australian community, then what the judgments that are made at the pub or at the water cooler or at the golf course or wherever it might be are the very judgments which we should be informed about and listening to. Yes, it's not what the judge from his or her particular sphere of experience, though inevitably you draw on that, decides. It's meant to be, if we can identify them, these values shared more widely.
Just in the back row. Just pass it across.
Thank you. Ben Butler, Guardian Australia. Can I just ask you about Cobalt? In that case, the gentleman involved ran a book-up system in a remote Aboriginal community, and he collected from his customers all their debit cards, all their PINs, to get their money out of the bank and all the details of their income. And then when they got paid, he took all the money out of their bank accounts. If that's not unconscionable, what is?
Yes, well, you won't be surprised to know that as a respectful member of an intermediate appellate court, I won't be passing comment on an issue which divided the High Court as it did. I mean, the points you've drawn attention to explain why 3 of the 7 concluded that it was unconscionable, but the majority concluded that there wasn't an unconscientious taking of advantage. And beyond that, I think I can't usefully comment. I would have had my own view, but it's been examined exhaustively now at 3 levels. The judge at first instance held it was unconscionable. The full federal court unanimously held that it wasn't, and as I've said, the High Court was divided.
Ex-colleague of yours, Chris, at law school. When we studied law, equity wasn't a compulsory subject. I I'm assuming from your wonderful presentation this evening, you would think that in fact it should be a compulsory subject. Maybe it is now, I don't know. Some of the younger members of the audience might know, but it certainly wasn't when we studied it.
Well, now that you ask me, yes, I think it should be. I don't pretend to be an equity lawyer in any relevant sense, and we don't have an equity division of the Supreme Court in the way the New South Wales Supreme Court does. But I suppose, given all the illumination we get from equity about some fundamental moral principles, I would want every lawyer, law student going into whatever field of practice to be alive to alive to that dimension of law which is not just about the strict rules. It's perhaps relevant to mention I've helped create a course at Melbourne Law School called Philosophical Foundations of Law in order to encourage students to realise that there are underlying philosophical values, including contestable values, about which judgments are made either in lawmaking or in adjudication, and so far from it all being a preordained set of arrangements, it's all pretty much open for debate, and lawyers certainly, I think, should be moral reasoners, both about what they're doing, but also about whether the law they're called on to apply is fit for purpose. And I think equity is a very good introduction to that. What's fascinating, and I'm not sufficiently knowledgeable about the history, is the way the Court of Equity developed so early. And this extraordinary notion that the Chancery judge could say, well, I know you've got a binding contract, but I'm not going to let you enforce it because it would be against conscience. It's a fascinating notion, isn't it?
Yes.
Thank you for the oration. My name's Jared Brodie. I'm with the Consumer Action Law Centre, and so consumer advocacy is what we do. And so you talked in our language, and I really appreciate your advocacy for talking about unfairness. It's something that we've talked about for a long time. My question, though, is your argument that unfairness, or unconscionable less so, perhaps unfairness more, can temper the unbridled self-interest of business because it's simpler to understand. I guess the alternative is to bring rules, clear black and white rules. You can do this, you can't do this. I guess which is actually do you think has the most important role to play if we're actually caring about safety and well-being of consumers in the marketplace?
I would immediately defer to your experience as an advocate for and advisor to people who've been adversely affected by unfair or unconscionable conduct. You may conclude that those norms haven't afforded much protection, haven't produced much proactive moral reasoning in the marketplace, and it might be time to have some rules. I remain of the view, so far, for the reasons I set out in the paper, that general standards, provided they're understood and promulgated and attention is paid to them, are likely to be much better. One field I do know a bit about is occupational health and safety. And you may know that until about the 1960s, there were extraordinarily detailed prescriptions about what factory owners could and couldn't do. And there was a revolution in the 1970s, which began in England, that this was both almost impossible to comply with, but not in the end a very good protection against unsafety in the workplace. And there and now in all Australian states, we have general standards, general prohibitions. Let me put that differently. We have general duties which say an employer must, so far as reasonably practicable, maintain a workplace which is safe and free from risks to health. Now, it requires some spelling out in particular industries as to what compliance might look like. But I think the consensus remains that compliance is much more likely to be promoted when the standard is general and there's some associated uncertainty. I think the issue is not with the standard, it's with the fact that it's at the moment expressed in unintelligible language, and either we as lawyers and judges or the leaders of the, in this case, the finance industry, have just not done enough to say what it means. That there really is a conflict between the things which drive this corporation lawfully to maximise its profit. We have to comply with these provisions. We've got to restrain ourselves, at least if we think, as I suggested, there's a possibility that this might be unfair. At least I should pause and ask the question.
Question in the gallery?
Anne Wardrop from La Trobe Law School. I'm just wondering on that point, picking up on that point about saying that it's just that not enough is done to make known the general standards. May it in fact be that in the financial sector it's a question of the corporate, what we're dealing with large corporations, so we're taking a notion of unconscionability that may have been developed in person-to-person commercial interactions. Now we're dealing in, especially in the financial institution, large corporations. People may understand notions of unconscionability and unfairness, but the real question is how do you regulate these large corporations? And that's the issue, not so much people generally understanding. So it's a question of regulation and how do you get at the executives and so forth that may actually be running the show.
No, I completely agree with that, and that's why I thought what Commissioner Haynes said about culture was so interesting, because he evidently contemplates that those at management executive level will have a responsibility to create a culture in which each person marketing or engaging with a borrower will ask herself, is this ethical? I mean, you're right. If attention is not paid to that, then this is an empty standard. What I can't do is forecast how likely it is that culture will change in the way the Commissioner exhorts it should. Graham Samuel, former regulator, was quoted during the week speaking very pessimistically about whether the relevant corporations are trying to change their behaviour. Again, that's an empirical question, but it must be right, mustn't it, that we as a community expect them to change their behaviour. The law requires them not to behave unconscionably, and it may be that civil society needs to be speaking up on this issue, not just the poor consumer who gets her house sold, but we as observers of these dealings and occasional participants in them. That's partly why it seemed to me this was a topic worth raising generally, because we ought to be talking about it and making sure that, maybe when I next go and see my bank manager, I'll say, have you heard about unconscionability? Not that I am in the market for products which might push me to the limit, but you know what I mean.
Yes. Question? I think you'll have to speak up. That's right.
My name's Honourable. I'm an insurance salesman. And ethicist, so the sort of thing very close to my heart.
Did you say and an ethicist?
And an ethicist.
Wonderful.
Yeah, so an ethicist, there you go. The way I see it, it can be very difficult in the court area. The Australian Financial Complaints Authority, although it's become a much larger organisation than the Ombudsman, they make decisions that, from our perspective, are very different day to day, and they can do that because they don't have to base them on state overseas. What I'd like to ask is there anything the legal profession can do to bring about a more stable interpretation of fairness? For example, AFCA actually has no concept of fairness that they work with day to day. They say that they're working on it, but they've been working on it for 6 months and they still don't have one.
It's a terrific question, I think, and Whether the legal profession can do anything about it, I'm not sure, but if what you have is, as you describe it, subjective, variable, inconsistent, and entirely opaque, then it would suggest to me that the regulation is failing and will continue to fail. And it won't, perhaps there's a difficulty there, because inevitably there is scope for differences of opinion, but I would have thought your point is a good one, that if one of the regulators is not able to say in fuller terms the sorts of factors it's taking into account and what might differentiate between fair and unfair, then the industry is likely to say, well, we don't really know how to engage with this. And, you know, I'm familiar with tax rulings and guidance statements which the workplace safety regulator puts out for precisely that reason. You know, we want an understanding of how you view transactions of this kind or an industry of this kind. And it's surprising to me that that wouldn't be done as a matter of course.
Yes.
In law school. One of the things I think that's important to remember is unconscionability is, of course, as you've mentioned, a product of the equity jurisdiction. And the whole purpose of equity is to rectify the deficiencies of a universal principle. So it's very problematic to have a situation where you've got standards that are certain when you're focusing on individual, an individual context. So probably as a follow-on from the previous question, fairness is highly individualised for the equity jurisdiction, and unconscionable conduct is actually the main emanation, one of the main emanations of the equity jurisdiction. So it's difficult to give you an answer outside of the context in which it is being evaluated. And as Professor Finn has said, unconscionable conduct is almost a concept in search of a meaning. So you have to contextualise it, I think. Anyway, it's a comment more than anything else.
Thank you.
One more question, I think. Yes, here we are, just in the room.
Hello, Brian Horrigan from Monash Law School. Thank you very much, Justice Maxwell, for a jurisprudentially rich and wide-ranging discussion. May I assure everyone here that equity and trusts are safe in all Victorian law schools, because whether it's compulsory or not, you won't get your accreditation as a law school from the Victorian authorities unless you teach it. So it's safe. I was prompted by your speech, Justice Maxwell, to think about the impediments in both law school teaching and in commercial practice to the enlightenment you're asking us to strive for in the aspiration. I suspect from my days in practice, the mantra of we're here to give commercial advice, not moral advice, is very hard to break through as a mentality. So may I invite you, in light of what you've said, to give us some final reflections on how we break through that mindset or change that mindset, that you're not being asked to make your own personal, moral, idiosyncratic decision. You're asked to being asked to apply a standard that the law is asking you to apply.
Yes, I'm not sure that I can do better than say that because the law is a moral law, my duty as your solicitor requires me to point that out to you. And this is not just at the margins, this is at the heart of the ASIC law. It governs all business dealings in the financial area under the Australian consumer law, all other dealings. And I think the logic of what I've said is that the lawyer should not only reject that facile distinction between commercial advice and moral advice, and recognise that the convergence of the two is inescapable. It's what the law requires. So to say, I'm not here to give you moral advice, is to fail in your duty. Because you need to know, managing director, sales manager, whatever it might be, marketing manager, that if you or your employees engage in conduct which is against conscience, then the court will say so, and your conduct will on that account be unlawful. Not sure what's difficult about explaining that to a client. And I suppose what I'm raising for consideration is, why wouldn't that be obligatory as a matter of both the teaching of law students and then the advice that commercial lawyers give their clients? I mean, it won't happen every time, obviously, but at a certain point in the advice you're giving at least a consumer-facing commercial organisation, it would have to include that, it seems to me.
Ladies and gentlemen, I think we've taken up Justice Maxwell's time pretty well tonight. And
well, I have got lots of other things to do, Hartley, you're right. So.
and I think once again we should show our appreciation for his marvellous discussion and answering of those questions tonight. Thank you.
Thanks very much, Hartley.
Good. Very good. One or two things. I'd like to congratulate and thank the staff of the Foundation and of the Supreme Court for making all of the arrangements and setting it all up so that tonight ran well. I would like to thank Chief Justice for making available for us again this wonderful courtroom for the holding of this oration. I think it's been a very good night. It's been a great talk. And all I can say is travel safely home. Thank you for your attention.